Hi everyone, my name is Changez. I'm joined by my colleague Naomi Owen. We're both employment barristers at number 5 Chambers, and today we want to speak to you about long COVID. And we want to focus specifically on the after effects that linger on even once your body has fought off the initial infection. It's something which is baffling scientists, and we believe as employment lawyers, we also need to get on top of the issue. At the time of this recording, social restrictions are about to be lifted. The government is estimating around 100,000 new infections per day. And at the same time, scientists are telling us that if you catch COVID, there's a 10, perhaps a 20% chance that you might then go on to develop some form of long COVID. So in this seminar, we're going to focus really on 5 questions. Number 1, what is long COVID? Number 2, will it qualify as a disability under the Equality Act? Number 3, what approach should we take to the medical evidence? Number 4, what approach should we take to reasonable adjustments? And number 5, what are the risks of dismissing someone who has long COVID? Naomi, perhaps you could kick us off then. What are the scientists telling us about long COVID? Is it real?
Well, it certainly is real, and it's an ever-developing area of science, evidently, as with the short version of COVID. So far, over about 2 million people have reported experiencing persistent COVID-19 symptoms, and that's according to a study called the REACT-2 study, which has been led by Imperial College London and commissioned by the Department of Health and Social Care. Now, for those interested, REACT stands for Real-Time Assessment of Community Transmission. So taking random samples from 500,000 people across the population between September last year and February this year, they found roughly 1 in 20 have suffered at least one of the recognised COVID-19 symptoms for 12 weeks or more. And those symptoms, many people will know by now, but they include extreme tiredness, shortness of breath, chest pain or tightness, problems with memory and concentration, difficulty sleeping. Then you've got the more physical signs of the dizziness, pins and needles, heart palpitations, and so on, as well as then depression and anxiety, which may arise as a result as well. So there's a whole range of different symptoms that people suffer. And the survey has tended to show that certain demographics are more at risk than others. And we'll probably come back to this later when we're talking about Section 19 and indirect discrimination. But on Imperial's study, some groups appear more susceptible to the lasting symptoms of COVID-19 and the long version. And those groups are women, smokers, those who are overweight, people in deprived areas, those who have been admitted to hospital. And age also seems to be an exacerbating factor, with risk increasing by 3.5% with each 10 years of age. And in fact, a BMJ article recently revealed that the average age of someone suffering with long COVID is about 4 years older than someone suffering with the shortened version. In fact, the findings are sufficient evidence to cause real concern about the long-term health of the population. And that really means that long COVID is inevitably something that we're going to have to grapple with and deal with and factor in specifically as lawyers, employers and employees as we move forward and hopefully out of this pandemic.
Naomi, do people suffer in the same way? Or is there some kind of variation in the way symptoms present?
Yeah, it's a hugely broad area of symptoms, but there appear to be 2 very broad groups, really, of individuals suffering. So you get first suffering with respiratory issues, and the second, it's more akin to the chronic fatigue syndrome and those related symptoms such as that. And that the vastness of the different symptoms inevitably seems to have led to difficulties in determining the appropriate treatment pathway, as well as the recovery. So it's very much on an individual basis, particularly as it's such a nebulous nature that we're still learning about. So it's definitely not a one-size-fits-all scenario. And that's a really crucial fact for those such as employers who are going to need to implement policies to deal with the ramifications of this new condition. And the other feature of long COVID that's particularly difficult to maybe plan for is it's a fairly common issue for it to be a relapsing and remitting condition. So patients feel that they fully recovered, but actually then they relapse and it hits again a bit later. And in fact, I can see that issue particularly might cause some complications with whether long COVID is seen as a disability. Changez, I don't know, I saw last month the Trades Union Congress were calling for long COVID to be deemed a disability. What's your view on whether this will end up qualifying?
Yeah, I mean, that's certainly an interesting proposal by the TUC. But I think what you're telling us is that the science says that people suffer in different ways, to different degrees, and over differing periods of time. So I don't think we can simply take as you put it, a one-size-fits-all approach in the law if the science is saying that everyone is different. So my view is that it may qualify as a disability in some cases, but you've got to consider each case on its own merits. And in reality, what that means is going back to the definition of disabled in the statute, Section 1 and Schedule 1 of the Equality Act. And as we all know, that definition comes in 3 parts. So perhaps we can just try and explore how it might play out in the case of an employee suffering from long COVID. The first element of the definition is that there has to be an impairment. And here, tribunals, as we know, don't focus too much on the medical label or diagnosis given to an employee, but focus really on the effects of the condition. And if someone is suffering from chronic fatigue or breathlessness, that's likely to tick the box for a physical impairment. If someone is suffering from difficulty concentrating or brain fog, then that's likely to amount to a mental impairment. The second limb of the definition, does the condition have a substantial adverse effect on day-to-day activities? Again, it will come down to a question of degree in the individual case. But we know that the threshold is set quite low. So substantial adverse effect simply means one which is more than merely trivial. I think it's really the third limb, the requirement for the effect to be long-term, which is likely to give rise to argument. Given that it's a new condition, it will be rare to have a case which has already lasted 12 months. And I think the problem category of cases is going to be those where someone has long COVID type symptoms, they haven't yet lasted 12 months, and then everyone's mind focuses on the question, well, is it likely to last 12 months? We know from the old decision of the House of Lords in Boyle and SCA packaging that likely to last doesn't mean 51% chance likely, it means could well happen. We also know from a recent decision from the Court of Appeal in the All Answers case that the tribunal should not be applying some kind of hindsight judgment, but must place itself at the material time and make a prediction whether, as of that time, the condition is likely to last 12 months. My view for now is, given the REACT-2 study, and it specifically mentions a paper published in The Lancet, where patients are recording that they are still suffering symptoms at 7 months post-infection. I think a judge is likely to say, well, if it can last 7 months, why not 9 months? It could well last a year. And I think the low threshold in Boyle is probably met. So on balance, I think long COVID is something which is certainly capable of amounting to a disability under the Act. But given the uncertainty which shrouds the medical evidence, Naomi, do you have any guidance for employers or employees as to how they should approach matters of evidence?
Well, I think this is going to be the trickier aspect of potentially bringing litigation and defending litigation, because in terms of medical evidence available so far, as we've said, the effects of long COVID are so wide-ranging that it will always be important to look at the individual facts and compare those to the individual medical evidence that we have on each case. Now, the medical evidence, as I was reading about in the last month's BMJ, suggests that there is difficulty in deciding which treatment path to go down. For example, there's conflicting opinion about whether exercise is beneficial as treatment or not, depending on the symptoms that people are suffering. So I can envisage a scenario where there may be some difficulties regarding the medical evidence and what medical evidence to get. It may well be that medical reports specifically produced for litigation become more essential in long COVID cases than maybe we're used to, where previously we've tended to rely on the medical or the GP reports and records and any specialist letters. It will again be necessary to really tailor the type of medical evidence sought and provided for the purposes of litigation. For example, thinking about what expert report might be required for any particular employee. It may be a respiratory consultant or mental health expert or a cardiovascular specialist, depending on the symptoms of that individual. Some or all of those type of experts may be relevant for cases depending on those different symptoms.
Naomi, what if you're an employer and one of your employees comes to you and says, I've got long COVID? How would you approach that as an employer? How would you simply accept it at face value? Would you try and test the evidence? How practically would you go about it?
I think evidently it's still important for employers to sift out those with a genuine condition and those, which it obviously is a very genuine condition, or those who may have jumped on the bandwagon of social media hysteria, whether deliberately or psychosomatically. And if it's psychosomatic, that may be another issue entirely. But for employers where there will evidently be the use of occupational health reports as we normally see, but when managing employees with long COVID, I think it's still worth considering whether that is sufficient, whether those occupational health experts will have enough expertise in this new area that's developing, or whether something more specialist is required, even at the internal capability process stage and so on, so that the employer has the more pertinent type of medical evidence in front of them when they're dealing with whether it's absence management, capability process, or ultimately thinking about dismissal. It's going to be really important that they can show, I think, that they've got the right kind of medical evidence that's specific or tailored to their particular employee. And that's why I'm not convinced that GP records will be sufficient evidence upon which an ET will be able to decide if someone's disabled or not, given that GPs can, to some extent, tend to operate on their subjective history of their patients, understandably so. But Changez, with that in mind, and assuming that long COVID ends up being protected, or in some cases is protected as a disability, what issues can you see arising in terms of reasonable adjustments?
Well, I think reasonable adjustments are potentially in play. The difficulty for the employer is that there's still a big question mark over whether it's under a legal duty to make the adjustments. As you mentioned, decisions have to be evidence-based, but once you have something from occupational health, or once you have a specialist opinion, then as an employer, you really ought to be playing it safe. So you need to assume for internal purposes that you are under a duty, whilst at the same time, vis-a-vis the employee, you can say, we're not saying you're disabled, but we're simply, as a matter of good employment practice, keeping an open mind and trying to get the best out of you and exploring adjustments. But I think the common practices, or the PCPs, which are likely to require adjustment in case of an employee with long COVID, are any practices around the workload, the hours, or the physical tasks which an employee might be called upon to do as part of their normal job. Physical travel might be another PCP, and in that case, it's normally easy in some jobs to arrange a form of working from home. Of course, whether or not it's reasonable in a particular set of facts to make an adjustment will come down to issues such as cost, practicality, and the effectiveness of any proposed adjustment. Now,
one thing that I can see, and in fact, anecdotally, I've seen there's been a lot of concern about for employees is pay. If they're off so long that their sick pay expires, is there any duty of employers to extend that pay or compensate in some other way as a reasonable adjustment?
Yeah, I mean, it's a good question. I think cases have been tried in the past with reference to disabilities to argue that it's a reasonable adjustment to extend sick pay. The judges have said that in principle, it should be capable of being an adjustment, but the balance of the case law, and I'm thinking in particular of cases such as O'Hanlon and HMRC, they say that it will be rare for there to be a duty under sections 20 and 21 for an employer to put their hand in their pocket and essentially make up the shortfall in earnings. I suppose if you have a larger employer which has in place some kind of permanent health insurance scheme for its employees, then that puts a rather different complexion on things. If it's easy for an employer to help a long COVID employee to present a claim under the insurance policy, then that probably is an adjustment which is reasonable for the employer to make. But I suppose there's a bigger question in all this, isn't there? What if it comes to the point where an employer simply has to grasp the nettle and has to consider head-on the question of whether the employment remains sustainable? Naomi, what do you think are the risks of a dismissal of a long COVID employee being found unfair or in some way discriminatory?
Well, it's certainly something that's going to be a real possibility, I think, depending on how the absence management is dealt with all the way through to any decision to dismiss. And starting off with then the absence management, it's now that it's even more important than ever that line managers, those using internal policies such as absence management policies, really know what their policies say. And maybe HR needs to take some time to look at whether their policies are fit for purpose in this new post-pandemic climate we have, because they really have to be alive to the idiosyncrasies that long COVID is throwing up. Something else to be mindful of is the disengagement of employees who are off on long-term sick, which is something that often is inevitable. And it can be a problem that can unfortunately lead to resentment and ill feelings just through a lack of understanding or a lack of communication on both sides of the fence. So it's really important that communication throughout any long-term absence is kept up on both sides. And that means employees have to engage as well. And I certainly think it would be really prudent for whether it's human resources or a line manager to keep a running log of any thought processes or decision making that takes place. So, for example, if reasonable adjustments are required or requested, why those are accepted, why those are turned down, so that the employer has contemporaneous evidence of their decision making, which may be helpful if a trial, hopefully a trial will be avoided, but if a trial and final hearing was necessary, because we're now looking, unfortunately, at claims being presented now, they won't be heard until 2023. Unfortunately, that's the realistic timeframe at the moment. So it's really important that evidence is kept in regard to decision making, and for employees as well, keeping a contemporaneous note of what is asked for, what is requested, why it's needed. All of that may be of assistance to a tribunal if it was to end up at that position. And in terms of that ultimate sanction of dismissal, and considering the Section 15 discrimination arising from, or the Section 19 indirect discrimination, obviously the last question in that list is whether the dismissal can be justified, whether the treatment or the practice criterion and provision can be a proportionate means of achieving a legitimate aim. And for some sufferers, I can think of one particular point that may lead to a justification argument being successful. And that's, as I mentioned earlier, if an employee is capable of working one day, but then off sick the next day, and that is entirely understandable and part of the condition. But from an employer's point of view, it could be disruptive to the workforce, or at least argued to be disruptive to the workforce. So that may be a possible way of justifying dismissal on the basis that there needs to be some certainty and reliability in the workforce that an employer can rely upon, provided obviously that all the normal pre-dismissal steps are taken and all the options are considered before you then get to the dismissal stage. So updated occupational health report, updated medical evidence from the claimant, capability procedure followed to the letter on both general fairness, but also any internal policies that are held by the employer. And hopefully the claimant or employee, should I say, would engage with that process. And then obviously reasonable adjustments, as you've discussed, Changez, have to be considered, including redeployment to other jobs and even a trial of a redeployment before that ultimate decision to dismiss is taken. But Changez, we mentioned earlier that there might be certain groups affected or differently, certain protected characteristics groups affected differently depending on the symptoms and so on. Do you see that having any potential impact on how long COVID cases come about?
Yeah, I mean, I think the study which you discussed, the REACT-2 study, shows certain trends, doesn't it? So, for example, older people are at greater risk of suffering from long COVID. So too women. And so too, one expects people who already have an underlying disability. For example, someone who has always had asthma might have that difficulty compounded by symptoms of long COVID. So those are three examples of groups who may be disproportionately disadvantaged by long COVID. So I suppose the question for the employer becomes, even if long COVID in a given case doesn't qualify as a disability in its own right, does it still disproportionately affect female employees, older employees, or employees with an underlying disability? I think employers here need to be careful, because they might, if they adopt a very rigid approach to employees with long COVID, for example, to take a very simple but concrete example, if an employer is quite mercenary and says it will make no adjustments for people who are off sick with long COVID, and it will dismiss people who are off sick with long COVID for a month or more, that can give rise to a practice which is indirectly discriminatory. There might be scope for arguing a justification, but again, that has to be thought through. So coming back to your point, Naomi, I think employers have to think strategically, especially when they have larger workforces, about how they're going to approach employees who come in saying they have symptoms of long COVID. It's something certainly worth reflecting on.
Yeah, thanks, Changez. Just to sum up before we go, I mean, we're yet to see really what the tribunals make of long COVID, aren't we? And I think although we've had a lot of first decision, well, not a lot, but we've had quite a few first instant cases come through now that are COVID related, they tend to seem to be related to the health and safety automatic dismissals or health and safety detriments. And then you've got the pay claims for complications arising from furlough schemes and so on. So really, this area of long COVID being a disability or other protected characteristics coming into play is new territory. But I say it's new territory. Really, it seems that there's nothing new legally, at least, that's posed for long COVID. It's simply, famous last words, a matter of applying the law as we know it, which is established, as we've mentioned, to each individual set of facts. Now, that sounds really easy. I'm sure it will prove to be far from it once this type of litigation gets going and starts making its way through the pipeline. But we'll have to just wait and see what the tribunals and quite possibly the EAT and upwards makes of it. But thanks everyone very much for listening, and thank you again, Changez.
Thank you.